These rules will be less relevant for us because we're not looking at listed companies in this course. But just understand that for an unlisted and a listed company, we have different methods of repurchasing shares, as I discussed, and then we'll have particular rules that apply to the listed company, and these rules are found in the company's ordinance and not in the listing rules. So when a general offer or market purchases are made, an ordinary resolution will be enough to approve the transaction. However, when we are dealing with a given member or set of members through a contractual repurchase of shares, then a special resolution will be necessary, and it will be necessary that any decision which will repurchase the shares of a specific group of members and force them out of the company, those members or member will have to vote on the decision because it affects them most. So this is something we'll see more with directors. When there is an interest, we try to divorce that interest from the approval process to ensure that the vote will take the entire company's interest into account and will not be tinged by the self-interest of the affected party. So in this case, like in altering class rights, when a particular person or group of persons may be damaged by the vote, then we give that person or group of persons the right to approve, to consent to the vote. If a particular person or group of persons were being benefited by the vote, then we tend to try to take the votes of that person out of the equation so as to achieve a neutral result. With a listed company, the funds used will be distributable profits or a fresh issue of shares. Listed companies do not make purchases or dividends on the basis of their share capital. Financial assistance is the second to the last transaction we'll be looking at today. And a financial assistance is essentially a transfer from the company to a purchaser of the company's shares in connection with the purchase of those shares. So when we look at the law, we see that if a person is acquiring or proposing to acquire shares in a company, and either the company or any of its subsidiaries, here control is important, assists the purchase directly or indirectly by making a payment before or at the time of the transaction, or reducing or discharging a liability incurred after the transaction, then we have the possibility of financial assistance. Financial assistance is generally forbidden because it would, given something that we haven't discussed yet, which is a scheme of arrangement or a merger of two companies. If we take a company which has significant debt and we merge that with a company which has significant credit, the credits and the debts of the two companies joining the merger will become part of the credits and debts of the resulting company. And so one technique which has been attempted in the past is a leveraged buyout that's still possible in the United States. So if, let's say, the acquiring company were to stock up on debt in order to purchase the target company, once it has purchased the target company, it can use the assets of the target company to pay off its debts. And so the aggressive acquiring company can acquire a well-funded target company without really any funds, simply by borrowing heavily, affecting the merger, and using the target's funds to pay off its debt. This is not good for the economy as a whole, and it's not good for companies which do try to make steady profits and accumulate assets to avoid insolvency. The types of financial assistance we see are essentially types that have grown up from reactions to evasion. So financial assistance is essentially a direct payment to the purchaser by a company or a subsidiary. And then if that is prohibited, then the next thing your client would ask you, well, isn't there an indirect way that we can do this? And so you show them an indirect way, which is technically legal. They do that. A court reacts to that later, or the legislature reacts to that. And next thing you know, you have a prohibition of an indirect payment. And then your client comes to you and says, well, isn't there a way we can do this without making a payment? And so you come up with an idea. Well, we could provide a guarantee for a loan that the purchaser takes out with the bank, and therefore facilitate the purchaser to acquire our shares. And so then a court reacts to that, or the legislature reacts to that. And what we have as a result is a prohibition that the guarantee, security, or indemnity that would be provided by the target company is also considered to be financial assistance. And so then the next thing your client asks for is, what if we do something after the fact? How about if we somehow facilitate it without making a direct payment, without making an indirect payment, without providing an official guarantee or security? And your idea is to forgive the debt at a later point, where a purchaser buys companies of the target, or shares of the target, and does not pay for those, and then we have a forgiveness of debt owed by the bidder for the target company, and that also now is prohibited. And we also have a catch-all, which is simply that any assistance that reduces the company or its subsidiaries' net assets could be financial assistance. In his typically commonsensical and accurate formulation, Lord Denning has looked at this particular phenomenon and said that you look at the company's money and you see what has become of it. That is, did it go to the purchaser of the shares? And you look at the company's shares and see if they went into the same hands where the company's money went, and then that could very well be financial assistance. Now, we have some exceptions to financial assistance, and they include something like a dividend, which is then used to purchase shares, a payment that takes place in a reorganization, for example, which is not made with the principal purpose of transferring or discharging funds to a purchaser of the shares. Of course, if you were to borrow money from HSBC and buy shares of HSBC with that money, this would not be financial assistance. If a company sets up a share ownership program for its employees, this has been specifically excluded from financial assistance. And so essentially with financial assistance, what we're worried about is a purchaser coming in to a company unfairly using the assets of that company in order to gain control or a strong position within the company. Minor transactions in the ordinary course of business, like employee share ownership schemes or purchasing the shares of a bank from which you borrowed money, will not be considered financial assistance, or more exactly, they may formally be financial assistance, but they are accepted from the application of the law. We also have the possibility of authorizing financial assistance. So for a small amount transferred, something not exceeding 5% of the paid-up share capital and reserves, the directors may approve financial assistance provided a couple of tests are met. That the company should give the financial assistance, it's in the best interest of the company, and the terms are fair to the company. Right? And that we have a approval by the directors. On the same conditions, all members may be, by written resolution, approve financial assistance.